Today, I am going to start a class for Indian Evidence Act 1872. First, we can understand a small introduction of the Indian Evidence Act. James Fitzstephen is the author of Indian Evidence Act. It contains 167 sections. 167 sections. It is divided into three parts. First part contains 1 to 55 sections. Second part contains 1 to 55 to 100. Third part is the 101 to 67 sections come under third part. First part contain 1 to 55. Second part is the contain 56 to 100. Third part contain 101 to 67. 167. 101 to 167. First part deals with the interpretation of words and relevancy of fact. Interpretation of words. First part 1 to 55 contain 1 to 55. First part contain interpretation of words. Interpretation and relevancy of fact. What are the facts relevant for admission, relevant for evidence before the court? It deals with within this section 1 to 55. 56 to 100 third part, which deals with the facts which need not be proved. Rules relating to oral and documentary evidence and the exclusion of oral evidence by documentary evidence. First part contains interpretation of words and the relevancy of fact. Second part 56 to 100, which deals with the facts which need not be proved. Rules relating to oral and documentary evidence. Exclusion of oral evidence by documentary evidence. Third part contains 101 to 167, which deals with the burden of proof and doctrine of estoppel. Competency of witnesses, examination of witnesses, and improper admission and rejection of evidences. First part contains 1 to 55, which deals interpretation of words and relevancy of facts. Second part contains 56 to 100, which deals with rules relating to oral and documentary evidence, exclusion of oral evidence by documentary evidence, facts which need not be proved. These are deals within the section 56 to 100. The second part. Third part contains 101 to 167, which deals with the burden of proof, rules estoppel, doctrine of estoppel, competency of witnesses, compellability of witnesses, examination of witnesses, and improper admissions and rejection of evidences. These facts are deals within this section 101 to 167. First, James Fitzstephen is the author of Indian Evidence Act. James Fitzstephen is the author of Evidence Act. It contains 167 sections. It is a procedural law which set the substantial law in motion. Evidence Act is a procedural law. It gives directions to the court how to make take evidences and other facts are deals within the Indian Evidence Act. Definition. What is meant by evidence? Evidence is a word derived from a Greek word evideia. It means to show clearly, to prove clearly, to make clearly. The word Evidence Act means to show clearly, to make clearly, to prove clearly. It is a Greek word evideia, taken from evideia. Evidence. There are two types of evidences. First one is oral evidence. Second one is documentary evidence. Oral evidence. All statement which the court requires or permit to produce before it by witnesses are called oral evidence. All statements which the court permits or requires to be made before it by witnesses are called oral evidence. All statements that is mainly gives importance to the statement means statement given by witnesses. All statement which the court permits or requires to be made before it by witnesses are called oral evidence. Second one is documentary evidence. All documents, including the electronic records produced before the court for its inspection, are called documentary evidence. There are two types of evidences: oral evidence and documentary evidence. Oral evidence means all statement which the court permits or requests to be made before it by witnesses are called oral evidence. All documents, including electronic records produced before the court for its inspection, are called documentary evidence. In the case Vijaypal versus State of Delhi, AR 2015 Supreme Court 1495, it deals with, there is some indiscrepancy. There is a difference between oral evidence and evidence given by by a doctor document. In this case, court declares that oral evidence given by the eyewitnesses are relevant. It is a simple case. It is the fact of the case is that an accused person inflict an stab injury to the deceased person sometime after he was died. Medical evidence, doctor given the evidences that he cannot live after the injury within 2 or 3 seconds. But eyewitnesses say that he ran more than 300 meter from the place. Court says that the evidence given by the eyewitness are relevant. Another important fact, is that what is meant by fact? A fact. What is meant? Fact means something that has actually happened. Something that has actually happened is called a fact. Which are perceived by a person through his sense are called fact. Something, state of thing or relation of thing which are perceived by a person through his sense are called a fact. Fact means something that has actually happened. Anything actually happened is called a fact. Which are perceived by a person through his sense are called fact. Example, that there are certain objects arranged in a particular order in a particular place. Certain objects are arranged in a particular place in a particular manner are called is a fact. Another, a man heard and saw particular something is a fact. A man heard and saw particular thing is a fact. A man said certain fact is a fact. Certain words, a man said certain words is a fact. A abused bee is a fact. First one is there are certain objects arranged in particular way in a particular place is a fact. Fact means something that has actually happened, which are perceived by a person through his sense are called a fact. The fact are of two types: physical fact and psychological fact. physical fact and psychological fact. Physical fact are example for physical fact are A abused B is a fact. Yes, A said certain words is a fact. A man heard and saw particular thing is a fact. Particular properties, objects are arranged in a particular way in a particular place is a fact. These facts can be perceived by a person through his sense, our sense, nose, ear, tongue, and touching, etc. These are physical fact. Physical fact means fact which are perceived by through his sense, our sense which can be perceived through our sense. These sense facts are called physical fact. Another is that a man has certain reputation. A attempted several times for killing B. A kills B intentionally. A intentionally kills B is a psychological fact. This intention and reputation that words are we cannot perceive through our sense. The facts which cannot perceive through our sense are called psychological fact. Example: reputation of a person made several attempts to kill B is an fact. At several attempt is psychological fact. Example: a man's attempt several times for killing B is a psychological fact. A has certain reputation. It is a fact, psychological fact. What is meant by fact in issue? Fact means anything actually happened is called a fact in issue. Anything actually happened is called a fact. Something which is actually happened is a fact. Example: certain objects are arranged in certain way. A abused B is a fact. A heard and saw particular something is a fact. Something actually, what is fact in issue? Issue means matters which are in dispute. Matters which are in dispute are called fact in issue. When the existence, non-existence, liability, disability, these are asserted or denied in any suit or proceeding are called fact in issue. In civil suit, some rights are claimed. By the plaintiff. These are disputed by the opposite defendant. These constitute fact in issue. One person raised his right, which are denied by the other, constitute a dispute. Any matter in dispute is called fact in issue. Example: whether B borrowed 500 from A or not. 500 rupees are borrowed by A from B or not. He executed a promissory note in favor of A or not. Alleges that B denies are issue. Alleges some fact. He did not execute the promissory note, but B alleges that he executed. This constitute fact in issue. Section 3 provides another thing is a document. What is meant by document? Any matter expressed or described upon a substance. Any matter expressed or described upon a substance. This substance, paper, metals or stone. Our book we are reading a textbook. It is a document. It is described or described upon a paper. We can see some matters are described upon survey stone. Some marks are described on the stone. It is a document. Any matter expressed or described upon a substance, paper. These substances are paper, metals or stones. By means of letters, English letters, figures or mark, for the purpose of recording that substance is called a document. Section 3 of the Evidence Act provide what is it is an interpretation of word. What is meant by document? Any matter expressed or described upon a substance by means of letters, figures or mark, for the purpose of recording that substance is called a document. Section 3 of the Evidence Act provides document. A writing on a paper is a writing on the paper is a document. Example, a map or plan is a document. A map or plan is a document. An inscription on metal plate or stone is a document. These are first one is when we briefing the matters. First one, James Fitzstephen is the author of Evidence Act. James Fitzstephen. It contains 11 chapters and three parts. It contains 167 sections. 167 sections. These 167 sections are divided into 3 parts. First part 1 to 55. It is interpretation of words and relevancy of fact. It contains relevancy of interpretation of words. Third part is 56 to 100. It deals with facts which need not be proved, documentary evidence and oral evidence, exclusion of oral evidence by documentary evidence. Third one is part contains 101 to 167 sections. It is it contains estoppel, the competency of witnesses, exclusion of evidences. These are all contained in third part. There are 2 types of evidences: oral evidence and documentary evidence. Oral evidence and documentary evidence. Oral evidence means all statement which the court permits or requests to be made before it by witnesses are called oral evidence. Documentary evidence, all documents including the electronic records produced before the court for its inspection are called documentary evidence. When discrepancy between the medical evidence and oral evidence, evidence given by the witnesses are 11. It is pronounced by the Supreme Court. In a case named Vijay Pal versus State of Delhi 2014 Supreme Court case. Another fact, something which is actually happened is called a fact. Any matter in dispute is called a fact in issue. There are 2 types of fact: physical fact and psychological fact. Facts which are perceived by a person through the sense are called physical fact. Psychological fact, facts which are not perceived through our sense are called psychological fact. Example, intention, reputation, etc. What is meant by document? Section 3 of the Evidence Act deals with describes or interprets what is document. Any matter expressed or described upon a substance. These substances are paper, metals or stones. By means of letters, figures or mark for the purpose of recording that substance is called a document. We'll repeat once again. Any matter expressed or described upon a substance. The name of the substance is paper, metals or stones. By means of letters, figures or mark for the purpose of recording that substance is called, that matter is called a document. Another proved, disproved, not proved. What is meant by proved? Section 3 describes what is meant by a fact is said to be proved after considering matters before it. Court believes that the fact is in existence. A fact is said to be proved. A fact is said proved means shows to be true by means of fact. A fact is said to be proved after considering matters before it. Some factors are produced before the court. By assessing this, court believes that the fact is in existence. That is said to be proved. A fact is said to be proved after considering matters before it. Some factors are before it. By considering these matters, court believes that the fact is in existence. A fact is in existence. That is proved. A fact is not proved after considering matters before it. Court believes that the fact is not in existence. A fact is said to be not proved after considering matters. The definitions are same. First one and second proved and disproved are same. Proved, a fact is said to be proved after considering matters before it. Court believes that the fact is in existence. Not proved, a fact is said to be not proved after considering matters before it. Court believes that the fact is not in existence. Disproved means a fact is neither proved nor disproved are called not proved. For example, it can be we easily understand by through an example. Proved. A commits murder of B. A commits murder of B, and A pleads that his act come under general exception. He kills B in order to save his life, and he produced witnesses. A produced witnesses that his act come under general exception to save his life. Court believes his plea and acquit him. Here, yes, plea is proved. Yes, plea is a plea. What is the meaning? He kills B in order to save his act come under general exception. It is proved. Not proved. A commits murder of B. A pleads that his act come under general exception. He produced his witnesses that his act come under general exception, but the court did not believe his plea. Witnesses' statement, oral evidences are not relevant, not to prove his act come under general exception. Here, court convicted him, sentenced him, convicted A. It is not proved. It is disproved. Disproved means when a fact is said to be disproved, after considering matter, court believes that the fact is not in existence. Another fact is disproved. A not proved. A commits murder of B. A never produced. A is not produced any witnesses, and the court did not believe his plea and convicted him. It is not proved. Here, if you want any short note of this evidence act, please call me in the number 8848481887 for 1848481887. Please call me. I will send you the printing note of the evidence act, the complete 167 section including evidence act. I will send you into money order. But 8848481887. We can start the class in next